Can you be sued for trying to save the world? Yes. Should you crawl under the bed and give up on trying to save the world? No. Not unless you've given up on democracy. Not unless you've given up on the notion that a nation that is founded on of the people, for the people, and by the people shall not perish from this earth. Go back and read the First Amendment again. Congress shall make no laws respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of people peaceably to assemble, and to petition their government for a redress of grievances. In 7th grade civics class, that phrase about petitioning for a redress of grievances sounded kind of archaic. But actually, our founding fathers thought that was the most important part of the First Amendment. They thought that we were the only country in the world that had ever been founded on the idea that your government had to listen to you and had to let you talk. That makes us pretty special. But there are now property rights groups that don't believe that. They don't believe that the First Amendment right to petition overcomes the sanctity of contracts. They believe that if you interfere intentionally with a contract in any way, that is what they call tortious or wrongful interference, and you're subject to damages. For almost 200 years, the right to petition never got questioned in court. We went by the theory that government doesn't have to do what you say, but they have to let you say it. And then, in the 1980s, the attack started. It was the corporate answer to silencing the activism of youthful protesters in the 60s and 70s. And now there's a rash of petition clause lawsuits against the petitioners, the people. The strategy earned the name SLAPP suit with 2 P's. Strategic Lawsuit Against Public Participation. SLAPP suits are not just about the environment and not just about youthful protesters. They've been filed in every state in this country. And they have been filed by the rich and powerful to fight back against those who want to be heard. In Colorado, for instance, back in the 1980s, a woman who talked to her school board member about the fact that the brakes on the school bus screeched got sued by the school bus company. And people have been sued who had concerns about what was happening in their neighborhood with a development project that they wanted to talk about. That religious groups have been sued for talking about the curriculum and what they'd like to see in it. More recently, Resolute Timber Company sued Greenpeace in California for tortious interference. And they said that Greenpeace lied because they said that the timber company, because of its timber practices, was a forest destroyer. And they put expert witnesses on the stand that said they had not destroyed the entire forest. Therefore, Greenpeace was guilty of tortious interference and owed them millions of dollars. The Standing Sioux were sued by the Dakota Access Pipeline Company. The pipeline company claimed that their protest, the Sioux's protest against the pipeline, was not protected by the First Amendment. And the Delaware Riverkeeper organization was sued by a developer who said that when they expressed their concerns about what his project might do to the river, they lied and they owed him money. In all of those cases, the petitioners won. But SLAPP suits aren't about winning. According to Wikipedia, in the typical SLAPP, The plaintiff does not normally expect to win the lawsuit. The plaintiff's goals are accomplished if the defendant succumbs to fear, intimidation, mounting legal cost, or simple exhaustion, and abandons the criticism. They don't care if they win as long as you shut up. And they count on the fact that if they shut you up, everyone else shuts up. If you want to learn more about SLAPP suits, there's a wonderful book written by Kanan and Pring called SLAPP, again with 2 P's, Getting Sued for Speaking Out. They have studied and covered SLAPP suits for 30 years all over the country. If you want to learn more about SLAPP suits and laugh at them, then just Google John Oliver SLAPP suits. John Oliver got sued. He finally won. Watch him laugh at SLAPP suits. But they're not funny. I am currently the Florida poster child for SLAPP suits. I'm being sued by a billionaire named George Lindemann in a case styled Lake Point versus Maggy Hurchalla. I lost in the circuit level, and I owe Lake Point $4.3 million. They took away my 2 whitewater kayaks. They took away my 2004 old Toyota. And they threatened to garnish my plain gold wedding band. We lost again at the 4th District Court of Appeals, and we're now appealing to the Florida Supreme Court. This is not a story about a poor little old lady who was destroyed by a billionaire bully and his snidely whiplash lawyers. I am 79 years old. I am not little, and I am not destroyed. I am proud of standing up for the First Amendment, and I'm happy and awed at friends and strangers who have donated and stood up for me, and for a wonderful bunch of lawyers. I would rather be me than George Lindemann. If he wins, his children can remember that he destroyed a bedrock of American democracy. Even if I lose, my grandchildren will know I never gave up for fighting for it. As Pogo used to say, it makes a man humble and sort of proud. If no one stands up to the big bullies, the little bullies are going to come out of the woodwork and they're going to take over the world. I'll give you a brief summary of what the Lake Point decision is about, but you can read all the gory details at the website slappmaggy.com. That's 2 P's in SLAPP and a Y on Maggie. And you can read the legal briefs in the case at defendmaggy.com. But this is not about me, and it's not about George Lindemann. This is about the First Amendment and the right to talk back to your government. When you ignore all the other problems in the lower court ruling, what it comes down to is this. Lake Point claimed Hurchalla lost her First Amendment privileges because, number 1, she made statements regarding studies of the project benefits that she knew were false or recklessly disregarded the falsity of. And number 2, Hurchalla lost her common law privileges because she acted through improper methods by making those same false statements and evincing ill will toward Lake Point by sending emails to county commissioners that instructed them to take certain actions with respect to the project, and were signed with names showing malice. As a defensive footnote, I told the commissioners not to close down the project in my emails, but to require them to meet the conditions it agreed to. Lake Point told the judge and jury that I was an influential, self-appointed environmentalist who hated all small businesses and decided to concoct a scheme and dedicate my life to destroying Lake Point. They said that I sent emails to the private email addresses of county commissioners who were my friends and who were ignorant about the issues. And my malicious intent was shown in two emails in which I signed, somewhat irreverently, one of those emails didn't even have anything to do with Lake Point. Lake Point and its principal owners are not a small business, and I don't hate small businesses. I am not a self-appointed environmentalist. I have won the National Wetlands Award from the Environmental Law Institute. I have won the National Conservation Achievement Award from the National Wildlife Federation. I'm in the Everglades Hall of Fame with Marjorie Stoneman Douglas and Nat Reed. That's probably why they chose me to sue. What I said in a public email to all of the commissioners that Lake Point said was a lie, that I knew to be a lie, was a study was to follow that documented the project benefits. That study has not been provided. There does not appear to be any peer review by the SLAPP team to verify the benefits of the project. SLAPP is the Comprehensive Everglades Restoration Program. George Lindeman Jr. early on promised me that there would be a SLAPP review of the project. That SLAPP review was never produced. But Lake Point told the jury, she said no studies were produced. Look at this pile of studies. And they produced a number of studies that showed there might be some potential benefit to the project. None of them were SLAPP studies. None of them were SLAPP reviews. I'm on my way to the state Supreme Court and standing in the road like a possum in the headlights because of the precedents that have been set in this case, both at the lower court and affirmed by the appeals court, in terms of the First Amendment and our right to petition our government. A friend of the court brief filed on behalf of a group of Florida environmentalists concluded if the $4.3 million judgment levied against the appellant is not reversed, most environmental advocacy in Florida will likely cease to exist. And it's not just about the environmentalist. Requests to appear as an amicus curiae, as a friend of the court, have also been posted by press groups, First Amendment groups, and religious groups. Kanan and Pring, who wrote the book on SLAPP suits, filed an amicus, and they said in the 30 years that they had studied SLAPP suits, they had never seen a case that more closely fits a description of SLAPP than this one. What are those precedents, and why should you care? Number one, you can successfully be sued for something you didn't say. The appeals court did not review the record and appears not to have read the email that I sent. Normally, an appeals court does not have to review the entire record of a lower court, but in constitutional cases, they are required to do so. Number two, at trial, I had an expert on the stand that said that the statements I made were true. The new precedent is, or at least it suggests, that disagreement between experts means one of those experts is willfully lying. Number three, you have no First Amendment privilege if you use improper method. The appeals court agreed with Lake Point that the following were clear and convincing evidence of improper method. The court said that it was telling that I contacted officials outside a public meeting. I attempted to influence commissioners who were my friends. I attempted to influence commissioners who were ignorant about some of the issues. And I was influential and therefore able to unduly influence them. Finally, proof of malice was my irreverent signature on an email about Lake Point that I signed Deep Rock Pit. How does that compare with existing precedents? What are we about to lose in terms of First Amendment rights that we thought we had? The standard for losing the First Amendment privilege is clear and convincing evidence of actual and express malice. You lied knowingly, you were lying for the sole purpose of destroying the business, and you did it with malice and malicious intent. The burden of proof is on the person who's suing you. According to existing precedent, to find actual malice, there must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication. I never expressed doubts about my statements. I believe they're true. I had a qualified expert witness who had served on the SERP review team who testified that my statement as to the SERP review of benefits was true. The Florida Supreme Court has held in the past that qualified privilege isn't overcome by the simple fact that a statement is false. They ruled that malice cannot be inferred from the mere fact that statements are untrue. A qualified privilege isn't overcome by the simple fact that a defendant makes a false statement. Florida courts have set a very high standard for finding express malice, which requires extreme hostility to gratify malevolence toward the plaintiff, such as ill will, hostility, evil intention to defame and injure. According to the court, express malice can be shown by the use of improper method. But when that liability would be based on expression to a government official on a matter of public interest, on the petition clause, only proof of malevolence can defeat the First Amendment privilege. I can tell you, except until I got through all this long lawsuit, I had no malevolence toward Lake Point. I was interested in what that project would do to the environment. Since the adoption of the First Amendment, the courts have allowed and encouraged boisterous disagreement in the public forums of democracy. Being wrong is not tortious interference. Being angry at the other side is not tortious interference. Your method, whether it's wearing armbands or speaking out or waving signs, whether it's in a public statement or on a phone call or in an email, those methods are not tortious interference. What is both wrong and actionable is to malevolently make up lies about a company for the sole purpose of putting them out of business. So, how do you keep from being sued? Honestly, you can't. Vengeful billionaires and deep pocket corporations are going to continue to sue advocates with SLAPP suits for as long as the strategy works. There are a disparate bunch of things you can do and not do that might lessen the threat. 1, make your complaint to government officials. The right to petition is actually stronger than the right of the free press or the right of free speech. Number 2, simply adding, in my opinion, will not save you. The 4th District Court of Appeals ruled in the Lake Point case that even if we view the statement as mixed opinion, the statement would not be privileged. Under the First Amendment, statements are not privileged opinion where the speaker or writer neglects to provide the audience with an adequate factual foundation prior to engaging in the offending discourse. Try to imagine saying all that factual foundation of what you want to say in a public meeting where your time limit to talk is 3 minutes. Number 3, using hyperbole can save you. If you feel angry at the other side, say something absolutely outlandish and you'll be okay. Jerry Falwell sued a magazine because they published a cartoon of him losing his virginity to his mother in an outhouse. The court said that was hyperbole, and they dismissed the case, saying that nobody could take seriously that it was an accusation about real fact. Number 4, you are not legally required to preserve all communications you ever make with public officials. They may be required to save them, but you're not required to save them. But once a lawsuit has been threatened or filed, you should save all emails, all written communications, all communications that you have had from that date forward on the subject. And the fact that, and you should not destroy the ones from that date backwards either. But remember, if you get sued at that point, don't discard any information about it. Save it, file it, have it ready. Number 5, that will not necessarily protect you. In the Lake Point case, the circuit judge opined that any time you criticized a wealthy corporation, you should know that you were going to be sued. And therefore, because you knew you were going to be sued, you were legally bound to save all communications from the first time you criticized that company. The judge then told the jury that since I was legally bound, and since I had said that before the lawsuit was threatened, I had gotten rid of all kinds of emails about all kinds of things because my email box was overflowing. He said that because of that, the jury could infer that I had destroyed important emails that would be important evidence in convicting me, and that they could use those imagined emails as evidence. Number 6, be aware that your email may be hacked and your phone may be tapped. I know that all of us try to get over our paranoia when we're on the front in advocacy battles, but the fact is that slappers are not nice people and they have very deep pockets. 7, it is probably not wise to be irreverent. I think that's sad. I like to take my causes seriously, but I try not to take myself too seriously. And we really should have fun saving the world. Number 8, always try to be accurate, do your homework, and keep a record. Back up those records so that they won't be hacked and lost. 9, if you get a threatening letter from the opposition attorney that seems to be absolutely ridiculous, don't just throw it away. Take the time to answer it in detail. It will not deflect the slapper, but it may be very useful if you get to trial, particularly in showing things that you didn't say. Number 10, get together with your allies. Make sure everyone involved understands the issues that you're petitioning about. Go to meetings en masse. Some public officials will ask you to appoint a representative to speak for all of you. Don't. It's we, the people. Let everyone say it in their own way as individuals. Repetition is okay. Number 12, work with state and national organizations to get backup research on your concerns. Number 13, lobby your legislature for strong SLAPP suit laws. Florida has a strong constitutional protection, but it has a very weak SLAPP suits law. 14, pay attention to local judicial races. Most people don't bother, and incumbents get reelected over and over. You're not looking for somebody on your side, you're looking for somebody intelligent and honest. Publicize your Bar Association judicial rating. Find good candidates to run and help them get elected. 15, help others being slapped. I have a wonderful long list of concerned citizens and groups that have donated to my SLAPP PAC fund and have petitioned to file Friends of the Court briefs. I couldn't do it without them. Number 16, join Protect the Protesters movement. You can find it just by Googling Protect the Protesters on the web. It includes ACLU, Greenpeace, Electronic Frontier Foundation, Freedom of the Press Foundation, and a whole bunch of other groups. Send the website link to all of your friends. 17, have parties and watch John Oliver laugh at SLAPP suits. It's fun. And you also learn a lot about SLAPP suits. 18, read Canaan and Pring. Their book on SLAPP suits. It's well written and you'll learn a lot. 19, if you are going to be a troublemaker in the eyes of those who are rich and powerful, it is time for you to do some estate planning. Your living will and your will are probably out of date anyway. You want to go to a very good lawyer and you want to make sure that everything is in order. If you are married and you intend to stay married, be aware of the fact that your bank will advise you to hold your account, your joint account, as tenants in common with rights of survivorship. Sounds good. The reason they do that is that way they can take half of the bank account away if they have a lien against you. What you want, if you plan to stay married and are fond of your spouse, is tenants in the entireties. In that case, you own it as a single entity, and the bank cannot take, bank or anybody else who's trying to garnish your funds cannot take half of it. 20, before you go to trial, demand summary judgment on constitutional grounds. Bring up constitutional grounds throughout the trial, not just in opening and closing statements. Let people know what their First Amendment rights are. And finally, the First Amendment is worth it. Democracy is worth it. Hug each other and don't back down. Have fun storming the castle.